Tujirani R. Chizumira, Stella I. Anukam, Tumisa B. Seveza Modibo Sako, Dennis D. Ajay, Duncan Gaswaga, judges, and Grace Wakio Kakai, Deputy Registrar. In accordance with Article 22 of the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9, Sub-Rule 2 of the Rules of the Court, Justice Iman D. Abudi, Judge of the Court, and the Nation of Tanzania did not hear this application. The facts of this matter, from the record, it emerges that the applicant, along with 4 other persons, were arrested for allegedly having committed an armed robbery on 3rd January 2014. It is alleged that the 5 accused persons were arrested during the continuous hot pursuit from the scene of the crime. Immediately after the armed robbery, the applicant was pursued by the police by car. As the police closed in on the applicant's car, the latter stopped his vehicle, disembarked, and started to run away. A police inspector then ordered a police officer to fire a shot in the air to warn the applicant to stop. But the applicant continued to run away. The police instructor subsequently ordered the police officer to shoot the applicant in the legs. The police officer carried out the order and shot the applicant in the leg, arrested him, and brought him to the police station. The 4 other accused were stopped and arrested separately at a police roadblock, which was deliberately put in place after the police was informed that the accused had left the crime scene and were heading in that direction. On the 22nd of April 2014, the applicant and the 4 other accused persons were convicted of armed robbery and sentenced to a 30-year prison sentence by the resident magistrates court of Mbeya. The applicant filed an appeal before the High Court of Tanzania at Mbeya, which dismissed his appeal on the 22nd of April 2016. The applicant subsequently filed an appeal before the Court of Appeal of Tanzania, which was dismissed on the 30th of August 2019. The prayers made before this court. The applicant prays for the court, 1, to find that it has jurisdiction to hear the application; 2, to find the application admissible; 3, find that the respondent state has violated the applicant's right to a fair trial protected under Article 7, Sub-Article 1C of the Charter, with regard to the right to be tried within a reasonable time. 4, find that the respondent state has violated the applicant's rights to liberty and personal freedom protected under Article 6 of the Charter. 5, find that the respondent state has violated the applicant's right to a fair trial under Article 7(1) of the Charter with regard to flouted criminal procedures during the trial. 6, find that the respondent state has violated the applicant's rights to dignity and the prohibition against torture, degrading, and inhuman treatment as protected under Article 5 of the Charter. 7, allow the application and make orders to quash the decisions of the respondent state's trial and appellate courts and order the release of the applicant from prison. 8, order the respondent state to pay the applicant reparations. And finally, 9, issue any other orders that the court may deem fit and just to grant. On reparations, the applicant prays to the court to grant the following orders. 1, the setting aside of both the conviction and sentence imposed on the applicant. 2, restoration of the applicant's liberty by releasing him from prison. 3, payment of reparations in the amount of United States dollars 30,000 to the applicant on account of moral damages suffered. 4, payment of reparations in the amount of United States dollars 15,930 to the applicant for loss of income. 5, payments of United States dollars 20,000 for the applicant's dependents, who are wife and 3 children. And finally, 6, any other orders that this honorable court may deem fit and just to grant. The respondent state prays the court to grant the following orders. 1, declaration that the court is not vested with jurisdiction to determine the application. 2, declaration that the application has not met the administrative requirements provided in Article 56, Sub-Article 5 of the Charter, read together with Rule 50, sub-rule 2E of the Rules of the Court of 2020, that the application be declared inadmissible. A declaration that the respondent state has not violated the provisions of Article 3, Sub-Article 1, 2, 5, and 7 of the Charter. A declaration that the applicant was arrested, tried, and convicted in accordance with the laws of the respondent state and international human rights standards. 6, that the application is devoid of merit. 7, that the application be dismissed. 8, that the costs be borne by the applicant. And finally, 9, any other relief this court will deem fit. After deliberations, this is the decision of the court. For the reasons already given, the judgment, the court unanimously on jurisdiction, 1, dismisses the objection to its jurisdiction. 2, declares that it has jurisdiction. On admissibility, 1, the court dismisses the objection to the admissibility of the application. 2, declares that the application is admissible. On merits, the court holds that the respondent state did not violate the applicant's right to be heard under Article 7, Sub-Article 1 of the Charter regarding the manner in which the proceedings before the domestic courts were conducted, including the consideration of the evidence. 2, the court finds that the respondent state has not violated the applicant's right to be tried within a reasonable time under Article 7, Sub-Article 1D of the Charter with regard to the total duration of the time it took to finalize his trial and appellate proceedings, as well as the time it took between his arrest and his arraignment in court. 3, the court holds that the respondent state did not violate the applicant's right to dignity and prohibition against torture, degrading, or inhuman treatment under Article 5 of the Charter with regard to the force used by the police during his arrest. And finally, the court holds that the respondent state did not violate the applicant's right to liberty protected under Article 6 of the Charter regarding his arrest, detention, and imprisonment. On reparations, the court dismisses the prayers for reparations. On costs, the court orders that each party shall bear its own costs. Signed by Blaise Chikaya, President, Shafika Ben Saula, Vice President Rafa Benashu, Judge Susan Mengi, Judge Tujirani R. Chizumira, Judge Stella Ayanukam, Judge Dumi Sabin Sebeza, Judge Modibo Sako, Judge Dennis D. Ajay, Judge Duncan Gaswaga, Judge, and Grace W. Kakai, Deputy Registrar. In accordance with Article 28, Sub-Article 7 of the Protocol and Rule 70, Sub-Rule 2 of the Rules of the Court, the separate opinion of Judge Rafa Benashu is attached to this judgment. Done at Arusha, this 6th day of March in the year 2026 in English and French, the English text being authoritative. Thank you, Mr. President.
Telle est la décision de la Cour.
This is the decision of the court.
Décision numéro 3. Voilà. Troisième décision.
Third case, application number 066/2019, Songlei versus the United Republic of Tanzania. This case, this judgment will be read by Honorable Justice Swaga. We want to know if the parties are represented in this case. Thank you. And the applicant? In the absence of the applicant, we are going to proceed with the reading of this judgment. Honorable Justice Gaswaga, you have the floor.
Thank you, Mr. President. This is the judgment in the matter of Songlei versus the United Republic of Tanzania. Application number 066 of 2019. The court composed of Blaise Chikaya, President, Shafika Ben Saula, Vice President, Rafa Benashu, Judge Susan Menge, Judge Tujirani R. Chizumira, Judge Stella Ayanukam, Judge Dumisabi Nsebeza, Judge Modibo Sako, Judge Dennis D. Ajay, Judge Duncan Gaswaga, Judge and Grace Wakio Kakai, Deputy Registrar. In accordance with Article 22 of the Protocol of the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9, Sub-Rule 2 of the Rules of the Court, Justice Iman D. Aboud, Judge of the Court and the Nation of Tanzania, did not hear this application. The facts of the matter. It emerges from the record that on the 6th of November 2015, the applicant was arrested with 3 other Chinese men after they had crossed the border into Tanzania from Malawi, and the border police had found in a secret compartment of their car 11 pieces of rhinoceros horns valued at $480,000 United States dollars. The applicant, who is the owner of the said car, together with the other 3 other Chinese men, were charged in the Magistrates Court with 3 counts under the Economic and Organized Crimes Control Act 202 and the Wildlife Conservation Act number 5 of 2009 for the following offenses: 1, leading organized crime; 2, unlawful dealing in trophies; and 3, unlawful possession of government trophy. On the 17th of December 2015, all 4 men were convicted as charged and sentenced on the first count to 15 years in prison, on the second count to a fine of $836,000 US, twice the value of the trophies, or 3 years imprisonment, and on the third count to 20 years in prison and a fine of $4,180,000 US, which is 10 times the value of the trophy. On 3rd February 2016, all of them appealed against the conviction and sentenced to the High Court of Tanzania, sitting at Mbeya. On 8th November 2016, the High Court of Tanzania acquitted the 3 other Chinese men on all 3 counts, but upheld the second and third count against the applicant. The applicant and the Director of Public Prosecutions of Tanzania appealed against this decision to the High Court of the High Court to the Court of Appeal of Tanzania. And on the 30th of August 2019, the Court of Appeal of Tanzania upheld the High Court's judgment. Prayers made before this court. The applicant prays the court to 1, allow his application; 2, quash the whole proceedings of the National Court which violated the applicant's human rights; 3, set aside the conviction and sentence; 4, order the release of the applicant from prison; 5, order the respondent state to compensate the applicant; and 6, allow the preparation of the compensate documents before the court during the hearing. The respondent state prays the court to 1, declare that the court is not vested with jurisdiction to determine the application; 2, declare that the application does not meet the admissibility requirements provided in Article 56, Sub-Article 5 of the Charter, read together with the Rule 50, Sub-Rule 2E of the Rules of the Court of 2020. Declare the application inadmissible. 4, declare that the respondent state did not violate the provisions of Article 3, Sub-Article 1, 2, 5, and 7 of the Charter. 5, declare that the applicant was arrested, tried, and convicted in accordance with the laws of the respondent state and international human rights standards. 6, declare that the application is devoid of merit. 7, dismiss the application. 8, order the applicant to bear costs. 9, grant any other relief that the court finds fit. After deliberations, this is the decision of the court. For the reasons already given, the court unanimously on jurisdiction, 1, dismisses the objection to its jurisdiction. 2, declares that it has jurisdiction. On admissibility, the court dismisses the objection to the admissibility of the application. 2, declares that the application is admissible. On merits, 1, the court holds that the respondent state did not violate the applicant's right to be heard under Article 7, Sub-Article 1 of the Charter regarding the manner in which the proceedings before the domestic courts were conducted, including the consideration of the evidence. 2, the court holds that the respondent state did not violate the applicant's right under Article 7, Sub-Article 1C of the Charter, read jointly with Article 14, Sub-Article 3A and F of the ICCPR on the right to defense with regard to the right to be assisted by an interpreter. 3, the court holds that the respondent state did not violate the applicant's right to be heard, protected under Article 7, Sub-Article 1 of the Charter, read jointly with Article 9, Sub-Article 3 of the ICCPR concerning the applicant's right to bail. 4, the court holds that the respondent state did not violate the